Hello, everyone. Good morning, afternoon, and evening. Thank you for your patience while we were getting this set up. We are excited to have you for another installment of our new series, Voices from the Litigation Frontlines. A few housekeeping notes. Please remember to mute yourself when not speaking. The microphone icon is located at the top of your control panel and should be red for those of you joining us online. We anticipate a large audience, so we may take questions at the end. Please feel free during the presentations to type any of your questions into the chat box, which is located at the bottom of your control panel. And for those who are interested, this session will be recorded and a recording will be sent to attendees and absentees. If you have any other questions, please feel free to shoot them to me as an organizer. And we also have handouts located in the bottom of your control panel for download as well. And today's topic is strategic litigation under the Convention on the Elimination of All Forms of Discrimination Against Women, otherwise known as CEDAW, and two leading organizations, Solidarity Center and Women's Link Worldwide, have used CEDAW to great success on behalf of survivors of human trafficking, domestic violence, and labor rights violations. Our first speaker joining us is Gema Fernández, managing attorney at Women's Link Worldwide, where she litigates before national and regional courts and UN treaty bodies in cases concerning gender-based violence against women, discrimination, human trafficking, or sexual and reproductive rights. And our second speaker today is Ziona Tanzer, senior law specialist at the Solidarity Center, where she works on labor, human rights, and gender issues. And Ziona is a South African lawyer who has worked at the Legal Resources Center and clerked at the South African Constitutional Court. So without further ado, I will hand it off to Gema. A copy of Gema's presentation I'll put in the chat right as she begins, so don't worry about that. And let me just change to Gema Fernández. Second, sorry, one second, bear with me. There we go. All right, Gema, take it away.
Thank you so much, Sarah, for the introduction and for the invitation and for organizing this session, this panel. Hello, everybody. It's a pleasure to be here. Can you see my presentation now? Is it okay?
Yes, we can.
Okay. Because now what happens is my computer won't move the slides. It's a bit stuck. So I'm trying to make them move, but so maybe shall we swap, Sarah, and you can move them for me.
That's totally fine. Sorry, everyone. Thank you for your patience. We test these things out, but then day of, you never know what's going to happen. So, showing my screen.
Exactly. Sorry about that.
No worries. All right. Are you seeing the screen now?
Yes. Thank you so much, Sarah.
And just please tell me to advance slide whenever you need.
Okay, thank you. So we can, advance slide, please. So just to start with, just a quick note on something that, sometimes might sound a bit obvious, but that I have found it's not that obvious speaking to colleagues and to people who engage in litigation, which is like, obviously, CEDAW, the convention, is a very good option it's a really good instrument to use in cases regarding violence against women, discrimination against women, generally women's rights violations, but obviously it's not the only international instrument that we can use when it relates to women's rights, which is apparently something that I've been, not apparently, it's something that I've been hearing here and there. And just a reminder of all the different UN treaty bodies that depending on the context where you're working and depending on whether the state has ratified their optional protocols, but like the wide range of instruments that we can use depending on what type of case are we wanting to bring, what are our facts, and what is the the major focus of the rights violations that we are wanting to redress and to seek justice for. And this is also a way for us to also strengthen the jurisprudence of different bodies with a gender perspective, which I think is also something that is very much needed. So following slide, please. And so what is like the relationship of CEDAW trafficking and labor exploitation? Slide, please. It's going to be like, yeah, you give it and they go pop up.
Okay.
So the convention does not have, like does not speak explicitly about exploitation or labor exploitation. It does speak concretely about trafficking in Article 6. As you can see by the text of the article, it was conceived thinking more about sexual exploitation and sexual trafficking, that generally trafficking, but for other purposes other than sexual exploitation. But obviously, as the the reality evolves and the jurisprudence and the instruments developed by the committee, obviously this article can be used to address different types of trafficking other than and not only sexual exploitation. Article 11 talks about the elimination of discrimination against women in the field work regarding to equal opportunities for employment, remuneration, conditions of labor, and social benefits. So it's really an article that could be the basis of a communication regarding trafficking for labor exploitation. And then we've got the instruments that the CEDAW committee has developed, such as its general recommendations. General recommendation number 16 on unpaid women workers in rural and urban family enterprises concretely affirms that unpaid work constitutes a form of women's exploitation that is contrary to the convention. So we see that the committee very much has been looking into this issue. Also, general recommendation number 26 on women migrant workers is a very important instrument, and the committee addresses their different forms in which women can face exploitation. And then general recommendation number 38 will be the GR on trafficking, that on Article 6, that draft, if you may want to have a look at how it looks at the moment. Slide please. So these are all different articles and instruments that you all can use on your work with the committee. Then I thought I would just say a couple of words about considerations when you're thinking about litigation before international bodies, and what type of strategic thinking there's behind this, and the choice of where to go when we have a case that we want to take to an international or regional body. Slide please. And concretely, well, this slide is comparing the system, the UN treaty body system with a regional system, concretely the European Court of Human Rights. But I think we can have similar considerations when thinking about taking cases to the Inter-American system or to the African human rights system, which is obviously like what type of rights are protected, like how the way in which rights are protected in under the different instruments is, I think, a consideration that is important to have a thought before deciding which form to go. Also, the specialization of the decision makers. Quite frequently, UN treaty bodies have a specific, I mean, if we are going to go to CEDAW, then we know all 23 members are really amazing experts on discrimination against women and on structural discrimination, and will have an important expertise on the matter. Or if we are considering going to the Committee Against Torture, because our case has a component of torture. So usually the UN treaty bodies have a level of specialization that is interesting to take into account vis-a-vis the more general human rights legal background of judges or commissioners at the regional systems. Also, obviously, the procedural issues, because I would say, well, we all might be aware that UN treaty bodies usually are a bit, have simpler procedural requirements. So that might also be depending on if we have our case has exhausted all domestic remedies, or like looking into the technicalities of the case, then that might be also a consideration before we choose what forum we're going to be going to. And then also the type of precedent that we would like to create. Is it a regional one, or do we want to go for a more global one, since more countries are usually parties to the treaty bodies? And also the type of reparations that we're looking for, because we know also UN treaty bodies are usually very good at issuing recommendations with guarantees of non-repetition, and that recommendations that can create a more structural change. And then also other things to keep in mind, more lawyerly and more from a technical point of view, is, yeah, as I was saying, what type of procedure do we have, and how remedies have been exhausted properly, and whether the arguments have been raised before the national courts, and also have a look at the case law to see how much we have in our favor, and how much of an opportunity we have to open to set a new standard, to create a new standard that is not already there. And obviously also, I think the mapping our decision makers is also interesting to know whether there's some more will in one place or the other, maybe, or better knowledge to give us like a good decision. Next, please. And then another, well, and under the optional protocol, we know we can we can submit individual communications. We can use the individual communications procedure wherever we have a case, a person, a client, or a group of people that we are representing that are victims of a violation of their rights under the convention. And we know it's like a classic litigation procedure with an admissibility phase. Then usually not all the times you get an admissibility decision. Quite often the committees do a joint decision on the admissibility and the merits. We can bring third-party interventions. We can call experts and civil society organizations to join our case and present interventions. And then something very interesting as well is that we can file for interim measures when we present our communication. Following, please. Next slide. And then another option using the optional protocol is the inquiry procedure that we can activate through sending, yeah, you can press it and then it will pop up. Thank you. Which we can activate sending the committee information on serious, grave, or systematic violations by a state party of rights protected in the convention. So this is an interesting option whenever we are working on a context where workers' rights, female workers' rights are being violated in a serious, grave, or systematic manner. And to date, there's been inquiry reports about these different countries: Mali about female genital mutilation, the UK about abortion in Northern Ireland, Kyrgyzstan, Canada, the Philippines, and Mexico about the murdering and killing of women in Ciudad Juárez. And these are really interesting procedures, lengthy, but really the committee has done an incredible work in bringing to surface the structural discrimination that allows for these serious, grave, or systematic violations of rights. So it's also an interesting option to use. Next. Okay, and then obviously when we talk about using CEDAW or any UN treaty body, there's the question of implementation, because like a lot of people may say, well, but why the effort of going to using one of these mechanisms when then you get these recommendations that are really not legally binding, and what to do about that. So I thought I would speak a little bit about that, and also I would speak a little bit about a case that we brought against Spain some years ago. Slide please, where it's a domestic violence case. We also have a trafficking case pending in front of CEDAW, another trafficking case in front of the Committee Against Torture, but I rather not speak about those cases until they are decided. But this one, we got this decision from the CEDAW committee in 2014, finding the state in violation of our client's rights, who's a woman who victim of domestic violence, who was trying to protect her girl child from the violence of her ex-husband, who after divorce kept harassing them and exercising violence against them. And she was trying to protect her through visitation scheme with the supervision of social services. And then this man was ultimately granted to have visitation with the girl without any supervision. And he, as he had already threatened her with doing, he killed her child and then committed suicide. And the state was never willing to accept its responsibility, even though this woman had reported the violence in a number of occasions and was always very active seeking for protection orders. But then the courts decided that this man his rights as a father had more weight than their rights to life free of violence. So the CEDAW committee found that state was responsible of the death of her child, which was a great relief for her in terms of access to justice and reparations. But then once we got the decision and tried to do different things and initiated conversations with the government in different ways, we realized the government was not willing to really do much about it and to do anything concrete to implement the decision. So we engaged in different types of strategies, alliance building with other organizations and the academia and other lawyers, other organizations interested in having a debate and bolstering a debate around the role of international law within Spain, and how these decisions, while they might be not strictly legally binding, but the government and the state should do something about them, because the state is a party when you're litigating, and they obviously defend themselves and participate in the litigation, but then when the decision comes down, they also need to do something about it. But then ultimately, we also engaged in communications activities, and we had our client was willing to speak, and she was spokesperson, which was really useful, because she's a very powerful person. Like she's a really good speaker. But ultimately, we decided we would litigate the case again, because what we were looking at as well was, like getting her access to compensation and to remedies for the death of the loss of her child. And also we were looking to set a standard that would say that UN treaty bodies' decisions had to have an effect in Spain. And that's what please, can we move the slides, please? I think I am now in the third circle, I think, the litigation one. And then we decided we would litigate her case again before the Spanish courts, and it took us like 4 years until we got the Supreme Court to declare that the decision of the CEDAW committee in her case had to be implemented, and it was legally binding on the authorities. And we finally got our client access to compensation to 600,000 euros for the loss of her child. And also we created this very interesting precedent for, you know, like human rights litigation in the country. Although obviously we've also there's been more recent case law and a couple of decisions from the Supreme Court trying to clarify that her case was a very particular case, and that this is not to be understood that you know, like generally UN treaty bodies decisions are to be considered binding. But now what we're doing is working with other organizations to maybe get a special procedure to implement these type of decisions in Spain and to have them be effective. So that's the success story that I thought I would tell, because you know, usually yeah, we can get a bit disencouraged to use these instruments, but yeah, there's also times when you can, you know, really get positive outcomes. So yeah, I think that's for now my presentation. Thank you.
Thank you. Thank you so much, Gema. While we're on this subject, does anyone in the audience have specific questions for Gema? Please send them either in the chat, or you can unmute yourself, toggle your microphone icon to green. All right. Well, as you're gathering your questions for Gema and hopefully for Ziona, I will change over to Ziona. Great. And for those of you interested, Ziona's presentation has been uploaded in the Handouts tab. Should be located near the bottom of your control panel. And you can download that, as well as our report and practice guide on using the CEDAW Optional Protocol. That is a mechanism that Gema was discussing just earlier. And while Ziona was setting up her share screen, we have a question for Gema. Gema, can you talk more about the national remedy in the Gonzalez case?
The national remedy, meaning like the, what do you mean exactly by the national remedy, sorry?
Which was the national remedy that was exhausted prior to going to the optional protocol?
Okay, so it was like an admin, so because the perpetrator committed suicide, there was no criminal responsibility to be sought through a criminal proceeding. So the procedure that was used was a civil, well, in Spain it's an administrative procedure, but I guess for those jurisdictions without administrative procedures, it's a civil procedure claiming the responsibility of the state and in the omission for the omission to protect Angela and her daughter from the violence that this man was exercising towards them, like from negligence.
Yeah, thank you.
Authorities.
And Sarah, do you want to just put my slides up?
That's totally fine. No worries. Again, everyone, technology is sometimes more of a curse than a blessing.
Yeah.
Just play, and please tell me to advance. All right, just let me know when to advance.
Okay, so hi everybody, thank you for inviting me to speak here. I'm just going to talk briefly about our experience with engaging CEDAW through shadow reports. I'm also going to talk a little bit about a shadow report we did to the International Covenant on Economic, Social, Cultural Rights, but very briefly because it's part and parcel of the same sort of enterprise. And so we are sort of experimenting with shadow reports. So I'm talking from limited experience of what we've achieved. So just a quick outline of what we're going to discuss. First of all, the background to how we got involved in shadow reports. I work for the Solidarity Center. It's a labor worker rights organization. Generally, we deal with the ILO and labor type instruments. And so it's a bit of a departure to engage with the CEDAW committee. And then I'll talk about how we went about in our shadow reports, and I'll focus on two case studies, one in Cambodia and one in South Africa, and what was achieved. So going on to the first one, the next slide. Okay, so the way the Solidarity Center works is that we have a central office based in DC where we have different themes, law, migration, gender, and we work with field offices in many countries all over the world. So the fact that we're doing sort of this type of legal work in a central office away from the field creates its own sort of difficulties and challenges. So I'm not based in South Africa, I'm not based in Cambodia, although I'm working on reports in these places. So how we sort of began to engage with the process of shadow reports was we started out doing research reports on a number of areas. So the one we did was on maternity rights, and we looked at the ILO, the International Labour Organization, and we looked at CEDAW and saw what the tensions were between those two ways of thinking about the same issue. We also did a lot of work on gender-based violence at work and looked at, again, ILO conventions and CEDAW and how they conceptualized it. And so out of this sort of research report, we sort of saw the advantages of a CEDAW. So first of all, transformative approach to equality and substantive equality, positive obligations expressed in very nuanced ways, the idea that omissions are sort of constitute a violation of rights, the willingness to engage with cultural norms. The cultural norms are part of and parcel of discrimination and need to be dealt with. So those are the sort of paradigms that we were looking at, and we wanted to take it further. And then there's also the practicalities. And in terms of doing a shadow report, it wasn't a heavy lift, really. And once you're dealing with these issues, once you've got reports, once you're engaged, it wasn't easy, heavy lift. And also that you get concluding, the observations come fairly quickly thereafter. So you're not waiting 2 years, for a judgment. It's fairly quick. And then also we were very interested in the role that international law plays in domestic court. So the previous speaker spoke how effectively CEDAW was used in their context, but in other contexts, or Cambodia and CEDAW, they both consider international law as playing a meaningful role in the domestic system of litigation. All right, so next slide. So the hows of shadow reporting, how we went about it. Okay, so first of all, so once we probably all know this, and this is probably all very basic, but once a state ratifies a convention, I think CEDAW has, I think it's 1 year, and they have to submit a report on how they've complied with their obligations under CEDAW. And then they have, every 4 years, they then have to come back and engage with the CEDAW committee on their obligations. So where NGOs come into this is that there's a two-part process. So the first part is that there's a list of issues that you put together, which you say these are the core issues that we think that the state is violating with respect to CEDAW. And then the committee looks at those issues and puts together its own set of issues or questions for the country. And then that becomes very, very, very central to the actual interrogation of CEDAW at the committee hearings. The second stage is the fuller shadow report. So the first stage is shorter. The second stage is the fuller shadow report. So the general thinking is that the first stage is crucial. So that's where you get your issues on the agenda, because there are obviously many issues that come to CEDAW. But we've had some experiences earlier where we didn't participate in the first stage. We only participated in the second stage and still were able to have some effect on outcomes. And then the second sort of issue is how you want to do your report. So are you going to be part of a broader coalition, which obviously there's strength in numbers, but on the other hand, your particular issue might get watered down. So in a broader coalition report, maybe Labour would be a paragraph, as opposed to writing a separate thematic report that focuses on Labour issues, and we can sort of go more in depth and make stronger arguments why these are important issues. So we've done both. We've worked with border coalitions, we've worked also separately. Then the whole idea of the research underlying the report, how do you go about it? We've also done it in different ways. We've worked with consultants, we've done focus groups, we use secondary research, we've done surveys in order to get information to put into this report. And in terms of the timeline, generally the full shadow report has to be in 6 weeks before the hearing. And there's a page limit of 20 pages. Then at the actual hearing, our partners were able to speak very briefly, to present on their issues. And once again, the concluding observations come fairly quickly. I think it's maybe within a month. So you've got immediate, which is very gratifying. You don't have to wait too long. And but obviously this whole process is dependent on follow-ups. So first of all, they're natural follow-ups in that this is part of a cycle, so that the country has to then come back 4 years later and explain what have we done with these issues. Then it also relies on civil society following up, so making these recommendations heard, having their input, using them effectively, so they're not just on paper, and integrating into domestic law as far as possible. All right, so next slide. So I'll give you our first case study is Cambodia. We did a shadow report for Cambodia. Again, Cambodia actually, in theory, it does consider international human rights law as part of its law. It has a role in domestic settings, and there's even a judgment saying that in the interpretation of domestic law, you must consider international human rights norms. How this functions in practice, it's not very clear. But it's there on paper, which sort of makes CEDAW and its recommendations potentially important. So the first study took place, the particular report we were doing was on the garment sector, which we work in. We have an office in Cambodia, which is, it's considered the engine of the economy. It's predominantly female and foreign owned, but it has particular challenges. Our methodology was we both worked with a broader coalition of NGOs. There's a NGO called NGO CEDAW, which sort of ran this process, and we contributed to that report. And then we also did our own separate report where we focused on the issues that we thought were central to our partners. Our partners, well, rather the Solidarity Centre staff and partners did a lot of survey work. So they went and they interviewed people. They did a lot of work to put together the report. Next slide. So maybe, I don't know if this is too much detail, but anyway, this is some of the list of issues that CEDAW prohibits discrimination in associations concerned with public or political life, including trade unions. And in Cambodia, we sort of argued that the registration requirements for trade unions were too onerous. It had an education requirement, and it required information, interpersonal information, which had gendered impacts. It would be particularly detrimental to women. We also dealt with gender-based violence at work and sexual harassment. CEDAW's labour law has a provision saying that employers must watch over the good behaviour and decency of women, and no sexual violation. We would argue this doesn't comply with the requirement to have a comprehensive law on gender-based violence. And then most importantly, not most importantly, but as importantly, is this idea of the gendered impacts of short-term contracts. So those women working in the garment sector are largely employed on short-term contracts, which basically they can not renew at will. And the effect is they're deprived of maternity protection. It also it impacts on their willingness to complain, because their jobs are precarious by virtue of the structure of employment. We put these in the list of issues and with questions to the government on what they're doing about these. In the fuller report, we added the impacts of unsafe transportation. We found that these women being transported to the garment factories also experienced a lot of particular unsafe conditions. Again, the more you put into the list of questions, the more chance you have that your issues will be on the agenda, which was the case. So let's move on to the next slide. Okay, so this is just our partners participating in the CEDAW hearing. They did get to submit orally, and they were asked further questions there. They submitted further information. Okay, moving on to the next one. So the findings of the committee, they found that there should be specific measures to ensure that women working on short-term contracts have labour rights and maternity protections, and that renewals, and there must be a cap of 2 years on the ability to renew. So this is a powerful recognition that short-term contracts have gendered impacts. Again, they spoke about that women shouldn't be excluded from domestic workers, and informal economy workers should not be excluded from labour protection. And they said the absence of a comprehensive law defining and prohibiting violence and harassment, including sexual harassment, is a problem. It should be prevented in the garment sector. And importantly, it said this covers commutes to and from work. So that was an innovation. We had not seen that before, and that was something we were hoping for. So those were positive sort of outcomes. Move on to the next slide. But again, relying on taking it back to Cambodia. So it's one thing to have this on paper. Now you have to use those norms in some ways or another. So our partners spoke to the newspapers, the meetings with governments. They did a lot to sort of bring back these findings to the country. And I guess in my work, so we were asked to do an analysis of gender-based violence laws. Now we have a norm in this report that we can now use. Instead of saying Cambodia should do this, we can say, according to the CEDAW committee, it needs to cover transportation and they need comprehensive laws. So it's an easily obtained norm. So that's Cambodia. Please go to the next slide. So the South African case is a little different. So South Africa, again, also has a legal context which is very friendly to international human rights law. Courts must consider it in making decisions, and it has historically played a very important role in the development of South African law. The two issues I'm going to talk about here, today deal with domestic workers. The first one is the exclusion of domestic workers from compensation in cases of occupational illness and injury. So if they got hurt at work, they don't have the ability to claim from a fund that other workers can. They have to go to court to litigate the issues. The second is the non-parity with respect to national minimum wage. So they are not included at the same level, domestic workers and farm workers, as other workers. So those were two sort of legal issues we were dealing with. Let's change to the next slide. So we again, going back to the original research paper, these were issues we had identified when we started doing this research. We sort of partnered with lawyers, and we worked with unions to identify a litigant, and we brought a case challenging the exclusion of domestic workers from compensation for occupational illness and injury. The particular case was there was a domestic worker who was partially blind. She was on a ladder cleaning windows. She fell into a swimming pool which didn't have a fence, and she unfortunately drowned. Her dependent went to claim compensation from the fund, and she was told, because your mother was a domestic worker working in a home, you aren't entitled to claim from the fund. She could, however, go to court and take the long route to court and fine, and it would have to prove fault, whereas the fund doesn't require fault. The fund you basically can just claim for. And so we litigated this case, and this case surprisingly was actually opposed. The government opposed this case, and basically the first argument was that it was that this kind of decision shouldn't be forced through the courts. The democratic argument that essentially let the legislatures take their time and change the law. The second issue was retrospective application. So even if they change the law, would it apply to our clients? Would it apply to all the domestic workers that had been injured or ill at work and couldn't claim from the fund? So those were the two issues of contention. And move on to the next page. Next slide. Oh, okay, so we're not there yet. But there were numerous delays and two cases, and so in this process of this long extended process of this case winding its way through courts, we did a shadow report to the International Covenant on Economic, Social and Cultural Rights. And we argued that these exclusions violate the right to fair conditions at work. We put on the table the national minimum wage and parity that excluded farm workers and domestic workers. We also addressed the issue of labour inspectors that actually you couldn't, even if you had the law, it would be difficult to do it because labour inspectors couldn't go into homes without the consent of the homeowner. And another issue which is related, not really related, but similar, is that we also put in there the issue of mining and occupational health and safety, so that there were women who had been, because of affirmative action and quotas, were brought into the mining sector, but the occupational health and safety provisions weren't taking into account particular gendered forms of violence and harassment. And so these we put in the shadow report amongst many other things. So we put maybe too many things, but nonetheless, let's go to the next slide. So they actually were very responsive to everything we asked for. It's surprisingly so. So they said extend quota to domestic workers. And they said regularly carry out unannounced labour inspections in domestic homes without prior warning and warrant, which is sort of quite phenomenal. My expectations were actually exceeded in what they were able to say. They spoke about domestic and farm workers having effective complaint mechanisms. On the mine worker issue, they said address the safety and dignity of female mine workers, address gender inequalities and violence, and eradicate male-dominated work culture with national minimum wages. Apply the national minimum wage across all sectors, raise and adjust to ensure adequate standard of living, and ensure that all workers, including precarious workers, effectively participate in decision-making processes and work conditions. So because domestic workers have a harder time accessing collective bargaining machinery, they were addressing that. So this was very effective. This was, as I said, not such a heavy lift. And now you have on paper sort of these findings you can work with and you can take forward into the domestic system. Let's move on to the next slide. I've been saying the arguable impact of shadow reports because of course there are many factors that might have caused success. But on the Malango case, the case we just discussed, the government ultimately withdrew their opposition and they agreed both the unconstitutionality and the retrospective application. And they put in place, they tabled a draft law which now includes domestic workers within this compensation for occupational injury and illness. So I think the shadow report was important, very important, because they had to answer as to why there was this sort of lacuna. On the other hand, there were other things too. There was protest action. The domestic workers themselves were totally visible and protesting outside every court case. We also did a high-profile research report, which we tried to look at other cases. What are the injuries and illnesses experienced in the home? And we found many. We found dog bites. We found, sometimes burglaries with domestic workers, who were working in homes that were burgled. So there were a wide range of different kinds of illness and injury that were experienced. So as that case now stands, it's waiting for confirmation in the Constitutional Court. Next slide. This is the domestic workers. They protested at every turn on the TV, on social media, really made their issues visible and known in a very powerful way. Moving on to the next. So another sort of result of the shadow report was that some of our partners there sort of formed a coalition to challenge the exclusion of domestic workers and farm workers from the same national minimum wage. And they began this campaign, the One Wage campaign, made submissions to the National Minimum Wage Commission. Again, that process is still ongoing. But again, now we have this norm saying that it's not okay to have these different tiers of wages for different sectors. That it should be uniform national minimum wage. And again, it's formed a broader coalition, so it's unions and beyond unions. Next slide. So with regard to CEDAW, we were actually before COVID came, we were in the process of submitting a shadow report on some of the same issues, arguing basically arguing about modifying the customs of CEDAW's non-discrimination in the private sphere with regard to domestic workers, that there's often laws, sexual harassment laws cover the formal workplace, but not the informal, and even when they do on the books, that in practice it's very hard to sort of realize those rights, and they're very particular issues that take place in the home. And against gender-based violence, sexual harassment, maternity protection, and unemployment insurance, that you have to be registered. It doesn't apply to the informal economy. And again, the pay discrimination issue we brought to CEDAW. This is the first stage of the process. And next slide. And so on the list of questions, they said, they asked the South African government to show the policies that address women and girls at risk of intersecting forms of discrimination and violence, recognizing domestic workers experience that form of discrimination and violence, and specify which laws and policies protect domestic workers, including wages, health and safety codes, vacation, monitoring homes. So we managed to get that on the agenda. Now we're on the final step of the process. Next slide. So just briefly, what I think the gains of the shadow reporting process in our fairly limited experience allows you to consolidate issues, to understand what they are, to actually use them in different fora. So once you know what they are and you've got your research, you can take it to different human rights fora. Participative, they have all been very participative processes, allowed for broader coalition building, and allows you to get very specific legal norms that you can then use in domestic settings. In the Quader case, it showed how it enabled us to bolster existing sort of litigation, and with regard to national minimum wage, allowed us to initiate a new litigation or new campaigns, and also it's very useful in absence of an effective domestic legal system or domestic legal remedies, like in the case of Cambodia. And that's, I think, where I'll leave it.
Thank you so much, Ziona. And let me just stop sharing my screen. We have about 11 minutes left for questions. We've had a few questions come in, so I will read these in the queue first, and then please feel free to keep submitting them or unmute yourself and ask a question. So Ziona, just pivoting off of your Cambodia presentation, a question in what concrete changes did the Cambodian government make in response to the findings of the shadow report?
So, I mean, I think it was last year, so this is very new. But I think that there's a new policy paper that sort of acknowledges they need to basically pass a more comprehensive sexual harassment law. So it's on the table. First of all, the visibility in itself, gets the issue on the table. And I think that they have a draft report where they are planning to, hopefully they're planning to take it further. And it's last year, so it's these things take time.
So stay tuned, basically.
Stay tuned.
Yeah. Gema, a question for you from Harriet Wistrich. I apologize if I got that wrong, from the Center for Women's Justice. And Harriet says that in the UK, they've become quite effective in using shadow reporting and but they have yet to succeed in achieving a positive admissibility decision in respect to the optional protocol. They've brought one very carefully prepared application to CEDAW. It took over 2 years to get an admissibility decision, which they ultimately lost. Unfortunately, it's not an option to appeal an admissibility decision, a negative decision. So all leading up to the question of, do you think there is a reluctance on the part of the CEDAW committee to consider cases under the optional protocol that come from particular countries, given that this is a body of people and they have their own biases and interests?
Yeah, interesting question. I'm not sure. I wouldn't think so. But it's also true that the committee is under a lot of work pressure, and they have they have quite a backlog of cases, and obviously there's issues as well with the funding that they get. There's always these tensions with the UN system about how much they get to be able to do their work properly. So I don't know if that makes them maybe want to prioritize some countries where there's a perceived notion that the rights violations are more severe or are more in need of action. But like I don't really have any information that make me think that this is the case. Yeah.
Okay, good to know. And Ziona, a procedural question for you on the shadow reporting. Can you submit a shadow report at any time, or can you only do it in conjunction with or in response to a state report? And also, how do you track the reporting cycles?
No, yeah, it's only in response to the state report, and it's all online, and they're also very responsive. So I think I emailed CEDAW many times. They respond to emails very quickly, so they'll tell you this is your deadline. The full report is 6 weeks before the hearing, and generally I think the preliminary list of questions is probably 3 months before. But it's both on the website, and again, you email them and they will reply to you surprisingly quickly.
And a quick follow-up on that, do the committee findings directly cite certain shadow reports? I was interested to know where we could find a copy of the findings in both of your case studies. And as a strategic matter, do you advise submitting reports in coalition with other NGOs? Do they prefer to see a large mass of groups on an issue?
So they don't cite the shadow reports, but you can sort of see what you put in there and what's come out. They do prefer you to basically have coalition reports because it's less work. But again, the disadvantage is you can't focus on your issues. You'll get a paragraph and you'll get less out of it. So we have found writing our own separate reports has been helpful.
Right. Gema, a follow-up question on the Gonzalez case. Did the plaintiff's client, did she receive compensation? Did the government actually pay the compensation to her?
Yeah, the government did comply with it. Well, there was the Supreme Court ruling granting her compensation. So this time the government, complied with the court's order and granted her the compensation that was awarded. Yeah.
And a follow. Oh, please go ahead.
I was just going to paste a link that I think it's really useful, like the link to do the follow-up on treaty bodies, with all the information about the sessions, the documents, the concluding observations per country, per treaty body, so I'm going to try and find a way to paste it in the chat box to share with everyone.
Oh, fantastic, thank you. And just a reminder for the audience, the compensation amount awarded was around 600,000 euros.
Yeah.
And then a few questions coming in about the optional protocol. This is for both of you. Have you either considered using the optional protocol in South Africa?
Well, so I'm based in DC, and we would love to use the optional protocol. We've always, worried about the exhaustion of domestic remedies, because that is something in Cambodia we spoke about, and that is definitely something we would like to do. And
we, in our practice guide on using the optional protocol for CEDAW, which we have in the handouts portal, we have noticed a large number of cases filed in Denmark, but fewer cases filed outside of the European region. And so for both of you, Gema, a lot of the case examples you gave on the inquiry procedure touched on all regions of the world where they also have their own regional human rights mechanisms, like the Inter-American Court or the European Court. For both of you, what goes into your decision-making process in choosing to go with this particular mechanism rather than a different regional mechanism?
Yeah, interesting. Well, I mean, both regional and international mechanisms are lengthy, but I think regional mechanisms, especially the Inter-American system, can be really slow, and so that might be one consideration. And also for cases where you want to bring this structural discrimination, intersectional discrimination, all these transformative equality concepts, all these ideas, sometimes the European Court of Human Rights, I think it's a bit behind, and quite often we would want to look for different forms for these type of cases. I mean, there's no general answer to that, because like you need to look at the case that you have at hand to make that decision. But those are some considerations that we would be thinking about.
Yeah, I think so. We would like to do both. So we are looking also at engaging the African regional system. So not mutually exclusive. This just, as I said, a little bit like an easy lift. The shadow reporting, and it helps you consolidate your issue, and the court sort of can lead into that. So they're sort of mutually reinforcing, and yeah, and it's just pragmatic. So it's your cycle's coming up, and it's there, and it's an opportunity to enter into dialogue and to sort of force the state to respond to issues in a very quick way, fairly quick way.
And is it either of your view that it's better to go with the CEDAW committee over other UN treaty bodies on issues concerning women?
Well, I mean, we did the International Covenant on Economic, Social, Cultural Rights, which was very responsive. But I think there are many other sort of treaty bodies you could use. CEDAW obviously lends itself because that's what they specialized in, but there are definitely other bodies that are responsive.
And we have a, sorry, Emma, go ahead.
Sorry.
No, please,
I was just going to say CEDAW is amazing in terms of anything that has to do with gender-based discrimination and gender-based violence. But there's also other committees like the Human Rights Committee, who has amazing also case law regarding women's rights violations. And I think it's interesting to have a look at the case law. So some committees are the Committee Against Torture, I would say it has some resistances, or I don't know, like you read cases here and there that that make you double think whether to bring cases to this Committee Against Torture. I mean, it's a matter of, yeah.
And we have a comment from Michelle Xiaolu in the audience, who just wanted to add that the committee findings through the inquiry procedure can be very helpful for advocates trying to challenge similar laws in different countries to the question about precedent. And so, for example, Michelle says that the CEDAW view on the Northern Ireland law on abortion is being now used to challenge the same restrictive abortion law in Malawi, and they're hoping to amplify the decision of the CEDAW committee in the Malawi context, which has the same law as Northern Ireland. So, Michelle, thank you for that comment.
Interesting.
Interesting.
And another question has come in. Do either of you know of any landmark cases that touch on commercial labor trafficking and complex fraud cases?
I mean, I don't know offhand. Can look and see, but I don't know offhand.
And we've had several requests to share contact information. Would either of you be willing to share your contact information in the chat box so people can connect with you? Great.
Yeah, sure. Are you getting my messages in the chat box? Yeah. Thank you. Great.
Well, we are right on the hour. Thank you everyone for your fantastic questions, and a huge thank you to Gema and Ziona for taking the time to share your successes using the CEDAW mechanisms. Based on the questions that are coming in, I think there's a lot more that we could spend an entire day on this. So I hope that you all can connect with Gema and Ziona in your own campaigns. Thank you for attending, and please remember to fill out the event survey when you exit and let us know what future topics you'd like to hear. Thank you for joining us today, and have a great rest of your day.
Thank you.
Thank you very much, Sarah and Ziona. Thanks, everybody.
Thank you all.
Bye.
Oh, no.